Good morning. Thanks for coming. Rob Bonta, California Attorney General, and we are here, as you know, and as you can see, at beautiful Dockweiler State Beach. And I did not bring you here as an excuse for a beach day. I brought you here to see firsthand what President Trump and the Federal Pipeline and Hazardous Materials Safety Administration are putting at risk. Our beautiful beaches, our beautiful coastline, our pristine coastline and Pacific Ocean, a multitude of businesses that rely on this area as a draw for their economic success, local communities and wildlife that call this place home. Trump's pipeline and Hazardous Materials Safety Administration, also called PHMSA, has unlawfully given the oil company Sable Offshore Corp the green light to restart pumping oil through two onshore pipelines that originate and terminate within California, starting in Santa Barbara County and ending in Kern County. One of these two pipelines ruptured, as you all know all too well, in 2015, causing the Refugio oil spill that dumped more than 100,000 gallons of heavy crude oil into the environment and at least 21,000 gallons into the ocean. A catastrophic oil spill that coated 7 miles of California shoreline and damaged beaches as far as 100 miles down the coast. A spill that looms large still in the memories of local residents, the fishing industry, and business owners. Fast forward to today. PHMSA's approval of Sable's restart of this potentially dangerous pipeline is the latest example of Trump doing the oil industry's bidding. These onshore pipelines are located in California and California alone. They don't cross any state borders, and they don't extend into federal water on the outer continental shelf. That means oversight of the pipelines is controlled by California, not the federal government. The Trump administration unlawfully undermined California's authority, unlawfully federalized the pipelines and usurped state control, and unlawfully issued Sable a sham emergency permit to begin pumping oil when there's absolutely no emergency. In short, the Trump administration broke the law again, which is why we are suing again, bringing our total number of lawsuits against the Trump administration to 55. This is our 55th lawsuit against the Trump administration, which has acted brazenly, blatantly, consistently, and frequently unlawfully. Before I dive into the details, I want to thank my colleagues at California DOJ's Environmental Justice and Protection Section and our Natural Resources Law Section, who have worked diligently to put this lawsuit together to hold the Trump administration accountable for threatening everything you see around us, and also much that you don't. I wouldn't be up here without them. So thank you to my great team. This lawsuit is not about whether or not the pipelines should ultimately be restarted. It's about who gets to decide, California or Trump. The answer is clear. The state of California gets to decide. The state of California decides where the pipelines run, gets to decide, and for good reason. The disastrous spill, the Refugio oil spill in 2015, was caused by corroded pipes from one of the Las Flores pipelines. Now, over a decade later, Sable doesn't like how the process is going, or the lawsuits that have piled up from local and state authorities. So Sable went crying to Trump. Sable said, "Jump," and Trump said, "How high?" Sable asked the president to declare the pipelines interstate, meaning they cross state borders, and to pretend the pipelines are part of a larger system that extends into federal waters on the outer continental shelf. That is a fallacy. That is not true. All of this is a pretext for usurping state oversight. Trump, from his cozy perch in the oil industry's pocket, dutifully complied. The Trump administration conveniently ignored the fact that in 2015, PHMSA itself deemed the pipelines intrastate, meaning solely within California's borders and within, therefore, California's authority. The Trump administration took control of the pipeline on December 17th, 2025. And less than a week later, it issued an emergency special permit to fast-track the restart of the pipeline. The permit was based on Trump's bogus declaration last year that we're in a so-called national energy emergency. A complete fabrication intended to curry favor with big oil and send business its way. We took Trump to court over that declaration last May. In fact, just last week, PHMSA announced that it will refrain from taking enforcement actions against oil and gas pipelines on the basis of the so-called national energy emergency, a clear indication that any purported concerns by the Trump administration over pipeline safety ring hollow. The Trump administration has no ground to stand on. The law is clear. These pipelines fall within California's jurisdiction. The federal administration has no right to usurp California's regulatory authority. We're taking them to court to draw a line in the sand and to protect our coast, beaches, and communities from potentially hazardous pipelines. This attempt to federalize an intrastate pipeline is just the latest wave in Trump's campaign to appease his oil industry buddies. Since Trump took office just over a year ago, the federal administration tried to freeze the development of offshore wind energy that will help reduce our reliance on oil, a move we blocked in court. It tried to withhold billions in funding for electric vehicle charging infrastructure that will help reduce our reliance on oil, a move we blocked in court. It terminated funds for solar energy development, upended California's Clean Vehicles program, and as mentioned, declared a bogus national energy emergency, all of which benefit big oil and all of which we've challenged in court. Trump made no bones about his plans to gut federal environmental protections or his desire to come after California. He's made good on his word, but so have I. When Trump breaks the law, I take him to court, period, full stop. When his lawlessness threatens our environment and our people, when he oversteps his authority to line big polluters' pockets, I step in, just as I am today. Before I turn it over to questions, I want to thank the incredible public servants at California DOJ who stand beside me in this work. I'm proud to call them my colleagues and grateful for their incredible service to our state. Anadel Almendras, Deborah Smith, Mi-Young Park, Vanessa Morrison, Matthew Bullock, Michael Dorsey, Mitchell Rishi, Rafael Hurtado, and Rebecca Hunter, all great public servants doing important work. I'm grateful for their contributions, and with that, I'm happy to take any questions that you might have. We think that because of the three decisions that were unlawfully made by PHMSA, the federalization, the restart order, the emergency special permit, that it could be happening in short order. And so obviously we think that the exercise of federal jurisdiction in this space is wrong. It's unlawful. It violates the Administrative Procedures Act. It's arbitrary and capricious, contrary to law. And so we want to get the right authority back in place, and that is the state of California. Because the federal government is moving quickly, a potential restart, and includes a restart order, a restart could happen quickly. So that's why we're moving with this lawsuit today. Thank you. We're filing today, and so we hope to get a order in short order. I don't want to predict exactly what the timeline would be, but we think it's pretty clear. The next step will be for the federal government to provide the administrative record to the court. This is a special proceeding. As you may have seen, we filed a petition in the Ninth Circuit Court of Appeals. So this is all subject to the Pipeline Safety Act. It's not the typical go to federal trial court in the federal district court, then the intermediate federal court of appeals, and then U.S. Supreme Court. We went straight to the Ninth Circuit, and the administrative record comes next, and then we hope to get an order in our favor soon thereafter. Sure. Well, let me just first say I'm speaking for myself as I answer this question. This lawsuit today is brought by me and also by a client, the Office of State Fire Marshal. So I don't want to speak for Governor Newsom. He can speak for himself. I'll speak for myself here. And in some of the other cases, we have multiple clients. So for those cases where we represent clients, the clients are the best positioned to answer any questions you might have about those cases. But I'll just speak about from my perspective here. I think you need look no further than the Refugio oil spill in 2015 to see why it's important for California to be able to have regulatory authority and oversight authority over the safety of these pipelines. It was a disastrous oil spill that hurt communities. It hurt our wildlife. It hurt our beaches, and we need to make sure that there is appropriate oversight ensuring safety. And that's why we're here at this beach, to show what's at stake. If there are rash decisions made by authorities who don't actually have the authority to make decisions and are giving passes to oil companies and not taking adequate, prudent steps to keep the pipeline safe, then you're playing with disaster. And we can't and we won't do that here in California. California has a duty and a responsibility to ensure safety of pipelines, oversight and regulatory authority of this pipeline is appropriately for the state of California, and so we're demanding that we have that authority and that we are able to make decisions going forward about the pipeline. Yeah, hi, sir.
You talked about the 55 lawsuits within, about, can you just talk in general about the extra workload for your office, just for this administration, focusing on that?
Sure. We brought 55 lawsuits against the Trump administration. My hope and my goal is that we would bring none. I don't think it's a lot to ask that the President of the United States of America follow the law, comply with the U.S. Constitution. But if he doesn't, it's his choice. So he decides how many times he's going to get sued. He decides when he's going to get sued. If he breaks the law, we sue him. If he doesn't break the law, we don't sue him. It's really simple. And so he's decided to put it into overdrive with his lawlessness. He's been a repeat offender. He's done the same thing multiple times, trying to take away funding that belongs to California, that's already been congressionally appropriated by Congress. He's in a different branch of government. He can't stop that funding. He's violated rights and freedoms. He's gone after California very transparently and blatantly. And so we've met the moment and rise to the occasion and taken a position and made a commitment that we have fulfilled, that every time he breaks the law, we'll sue him. So we have a great team working overtime. This is all avoidable if Trump just followed the law. But we've worked late nights. We've moved quickly. because so much is at stake, we protected $188 billion worth of federal funding for California, for Californians, for things like housing and health care and school, emergency and disaster relief. And we've protected constitutional rights, which are priceless. And we've had to move quickly and act quickly because of what is at stake and what Trump is trying to do. So it has put additional workload on us, but we walk and chew gum at the same time. We're doing everything that we did before and more, and we're doing this. Our job is to make sure we make the people's fights, the people of California's fights, our fights, and that whatever comes, whether it be affordability or public safety or a lawless president trying to take away their rights and take away their funding, that we are there. And so we're more than up to the task. It has been more work created by a lawless Trump, but we're doing it. We're doing it well. We got it under control. We got a full tank of gas. We're full of energy for whatever happens next. So we're ready for anything that Trump brings next. Yeah. I'd say I see you. I value you. We got your back. We're thinking about you. We know the damage that you have suffered and the pain that you've suffered with the Refugio oil spill, and we're committed to make sure that we have the authority to make decisions about the regulation and the oversight of this pipeline, and that safety be top of mind, and that the Refugio oil spill never be repeated, and that we take all steps that are prudent, appropriate, and lawful in that regard. And I will be representing many clients who will have the state authority that they deserve, who will make decisions. Those decisions will play themselves out. But it's important that the state of California have authority here. It is ours by law, and it is for us to exercise. So we're demanding in court today that we have that authority.